Hello, and welcome to Due Process. This is Trevor. Today, I'm joined by Mark Farrant, founder and CEO of the Canadian Juries Commission, a not-for-profit that supports individuals who have served on juries. Mark and I will be discussing topics related to jury service in Canada's criminal justice system, the psychological consequences that can result from such service, and the need for better juror support. As will become clear in our chat today, Mark is a passionate advocate for jury reform in Canada. Since serving on a jury himself, Mark has worked tirelessly to improve the support jurors receive in Canada. He has and continues to lobby governments in Canada to pass jury reform legislation and has been instrumental in some recent jury reforms in Canada. Mark, it was great to have you on the show. I know you're, as we chatted about a few moments ago, you're a little bit banged up right now with some ailments, but I appreciate you battling through your injuries to be here.
Oh, it's a pleasure to speak with you, Trevor. Thank you very much for the opportunity.
So Mark, I hinted in my introduction about your jury service, and that's how you've been put on this path to jury reform. But I just want to linger on your background a little bit more if we can. And if we could start with how you became involved with being on a jury and just your journey to advocate for jury reform in Canada and starting the Canadian Juries Commission. Can you give us a little bit more background on how this started for you?
Well, it goes way back to when I received a summons in 2014 for a first-degree murder trial in Toronto. It was the first time I received a summons in a long time. And at the time, I was an executive working in telecommunications. I had a young child and was expecting a second child along the way. And I was, reticent to respond to the summons, but was ultimately selected to be a juror in a graphic first-degree murder trial with an NCR defense that changed my life. I wasn't the same person walking out of that courtroom as I was going into it, and unfortunately learned the hard way and experienced the enormous gaps that exist in the system for individuals post-trial. And as I started to experience those and experiencing the closed door effect, so to speak, and the lack of support and the lack of available services that I expected to be there, I also wasn't willing to accept it and made it my mission to course correct it. But it was a long journey, certainly, to get there.
Right. Okay. And you mentioned, Mark, that when you first got the summons, you kind of had a traditional reaction that a lot of people do that, how am I going to get out of this? Why do you think that is the common reaction for people?
I think it stems, the insight it really is that it stems from decades of underinvestment in jury duty, a lack of investment from governments to promote jury duty. Our institutions, our education institutions have very little coverage of jury duty in high school curriculum, at the post-secondary level, even law schools. If you talk to people who've gone through law school, say, we really didn't cover it. It was shocking that it wasn't there. But it's the most important civic duty remaining, and really the only mandatory civic duty remaining in our society. We don't conscript for the military, but we certainly do for jury duty. Aside from elections, again, voting is a right, but it's also not mandatory. And so there are very few comparisons left in our society of a mandatory, legally bound participation. And so the brand equity, as you would use a marketing term to describe it, is poor because, again, of lack of investment, lack of promotion, lack of education, and lack of understanding, which is why, I'm doing the work that I'm doing now as part of the Canadian Juries Commission.
And just for our listeners, to give them some background, the jury that you served on was for the case of Farshad Badakhshan.
Farshad Badakhshan, yes.
Okay.
It was a not criminally responsible case, defense of a first-degree murder charge. And for your listeners, what that essentially means in legal terms, and again, I'm not a lawyer, but a not criminally responsible defense essentially means entering, in essence, a guilty plea, but not responsible for it as part of the defense because of a mental illness that made the individual incapable of understanding their actions. So that's the defense posture in that trial. And then it's really the burden of the Crown to suggest or provide the evidentiary base that refutes an NCR defense that says the individual was responsible. So it was a gruesome trial. It was graphic. It involved the murder of a young woman, Karina Petracki, who was a Ryerson University student in Toronto, who was murdered in her rooming house apartment by her on-again, off-again boyfriend, and a savage attack. And unfortunately, the victim died on the way to the hospital from her injuries. The perpetrator was in a medically induced coma for a year, suffering horrific wounds to himself from the event, but later came out of the coma and was charged with the crime.
And as you noted, you were exposed to some pretty gruesome evidence and visuals. When you first received a summons and going through the process of being selected on the jury, was there any discussion or preparation for potential juries about the type of evidence you would be exposed to?
There wasn't in this case, no. We were really, again, we were subject to what was presented in front of us. Again, the role of the jury is passive in the sense that you're receiving information from Crown throughout the trial. So you don't control the pace of the evidence as it's presented to you. You don't control the quality of the evidence. You don't control the frequency which the evidence is presented. It's literally there. Some cases, the justice might say that some of the evidence you're about to see is troubling. Those tend to be rarer in court, obviously, because you don't want to prejudice the jury in their decision making by an emotional response to the evidence that they might be receiving. So in often cases, you're just literally the evidence is presented. So it could be autopsy photos. It could be video evidence of the crime scene, video of the attack and the death of the individual, as was the case in the Chauvin trial in Minnesota. It could be anything along those lines. And also witness testimony is also evidence. And so graphic descriptions of events that may not even be obviously a homicide. It could be the described sexual assault of an individual by the victim in the case, and that's evidence. And so again, we were exposed to the autopsy, the description of the victim's wounds for quite some time. Police video footage of the crime scene. The perpetrator was in the courtroom as well, and because of the wounds that individual had suffered from inflicting upon himself in the case, he was a constant reminder of the brutality of the event as well, because all you had to do was sort of glance over your left shoulder and see him to remember how bad it was. And so the testimony can in many ways be psychologically damaging and traumatic, especially when you're seeing seasoned veterans and first responders break down on the stand describing their own experience in the case. It suddenly hits home how traumatic the event was.
And Mark, how long was this trial that you were involved in?
It was a 4-month trial in the end. There were a few breaks where the court didn't sit, but it was a 4-month trial.
And I should have looked this up, but this wasn't a case where the jury was sequestered. You were going home each night, right?
We were going home each night during the trial itself. Sequestered juries in Canada are very rare, where the jury is completely sequestered and cut off from the public during the events of a trial. Those tend to be the exception, as opposed to some of the trials that go on in the United States and other jurisdictions. So yes, we were going home. In fact, I was going to work, like a lot of jurors do, returning to your jobs and then maybe going to the office. And I would be there probably until midnight, catching up on the day's events and coming back into work the next day, because jury duty can be an enormous disruption to your life. Some workplaces might have an arrangement with you to say, listen, you're performing your civic duty. We respect that. Come back when you're ready. Other workplaces, no, that's not the case at all. You're going to get your job done. You're going to continue to do the work and on top of what you're doing. And so it was a long 4 months. Let's put it that way.
I bet. I maybe naively assumed that when you were on a jury, your employer would be allowing you to serve and not expect you to meet those employment obligations. But obviously that's not the case for a lot of people.
Well, so an employer I would say every jurisdiction in Canada, every province, again, for your listeners, jury duty is a federal mandate under the Canadian Criminal Code, but it's administered at the provincial level. So each province has their own jury act that in many ways could be very different from province to province and territory to territory. And the same would be said for your American listeners. Each state has their own jury act, very different. And then obviously federal crimes, and we don't want to get into that distinction there. So in most jurisdictions, it's illegal for an employer to dismiss you for serving on a jury or for accepting a summons. That's illegal, but an employer is not obligated in most jurisdictions to maintain an employee's salary or benefits during their stay as a juror. So you can be dismissed, as it were, to serve in court, and for the time that you're there in court, employer again might obligate you to return to work to fulfill certain hours of your employment. It really depends on your employer, whether they have, if you're unionized, whether there is a collective bargain in place and a collective agreement that supports jury duty. It really does depend.
All right. And yeah, I appreciate that it would depend on the province or jurisdiction that you're in. It's just surprising for me to hear just a ton for someone to deal with, to go through jury duty and then, like you did, have to go into the office after a long day of hearing troubling evidence and testimony. I can't imagine the toll that would take on somebody.
Sadly, it's something that is not uncommon, and that we've heard from a lot of jurors in our work said they had wished that they had been able to partition their employment stress from their civic duty and being able to focus entirely on the task at hand. Because a lot of jurors, what's very interesting is the transformation that occurs amongst a lot of individuals who might go into court upon being summoned and be upset, reject their role, but the moment they sort of sit down and start to participate, an enormous change comes over many, in they become deeply involved in the case, deeply committed to it, and understand their role and responsibility. And suddenly the decorum of the jury really changes, and it's quite remarkable to watch. And that's what we want to have. That's the appropriate response and what we're encouraging. And so the workplace has a role to play to support jury duty in the same way that we're supporting public health now amid this terrible pandemic that we're in. We need to do the same for our most important civic duty.
And we'll discuss here momentarily, Mark, about some of the reforms you would like to see incorporated in Canada and elsewhere. But I do just want to stay on your experience as a juror, just with respect to how this impacted your personal life and family life, where you're going through this experience for 4 months, you're still going home, you're still seeing your family. Can you just give us a sense of what that experience was like?
Well, you can imagine having a week of terrible, terrible testimony and terrible, terrible evidence placed in front of you every day consistently. Again, you don't control the cadence of the information that is presented to you. So you might be seeing things that you may never have prepared yourself before in your life. It's very different to observe that kind of evidence in court than it is to see it in a movie or to see it in fiction, when it's somebody's life, a life that's been taken away violently, and then to go home and to have to switch that off because you have to respond to your child, or you have to respond to your spouse, or you have to respond to work colleagues. It's very challenging, and we don't prepare the jury for that transition because, again, jury duty isn't a vocation. It's not something that you train up for. It's not something that we even put a lot of pre-trial investment into because of very real legal concerns about ensuring the sanctity of the jury and their impartiality. So you receive very little information at the out front of the trial and are bombarded with evidence and difficult legal subjects throughout the trial. So certainly day by day it was chipping away at me. I understood that this was stress, and there were days obviously where I was very obviously engaged throughout and very interested. And I knew this was stressful, and I knew what I was feeling in my body, the heightened anxiety and the tension. And I just assumed it would go away like anything else. And I had some experience in stressful situations throughout my career and in the workplace. I had volunteered for several hospices at one point in my life and had been through some trauma there. But those are things you sign up for, and you go in willingly, and you understand how this might affect you. That's part of the job, so to speak. Whereas jury duty, you're not prepared for it. So I was starting to shut down in terms of not socializing, not reaching out to people, not enjoying socialization. Throughout the trial, I was really trying to just keep things separate and was trying not to be influenced by anyone. That was sort of my own personal take on it. So I just took the role incredibly responsibly. But those feelings didn't dissipate when I left. They actually intensified.
And can you tell us how you came to discover that you had PTSD?
It was a long, dark journey, to be honest. And so, again, I was expecting those feelings to dissipate and go away. And so I entered this hyper agitated state. Shortly after the trial, a month later, my son was born, which was supposed to be a happy time in my life. And it wasn't, as it turned out. I didn't greet my son's birth with the same internal zeal as I did the birth of my daughter. I was really sort of acting as it was, feeling this darkness come over me. I wasn't sleeping, I wasn't eating properly. I'd shut off communications with friends and family. I was avoiding any type of social interaction possible and basically putting all emotional energy into keeping a neutral, brave face at work. And so my work colleagues just had no idea this was going on because, again, who are you going to talk to about this, which is one of the problems. So I just kept going on and on and on. And then finally, my family said there was something wrong and I needed help. And so began the next phase of the journey, which was trying to penetrate the mental health system in Canada.
And Mark, is there any data that sheds light on how often jurors develop psychological side effects from serving on a jury that you're aware of?
Not a lot. There's not a lot, especially in Canada, because again, the jury, unlike the US, where jurors are open to discuss the trial after the fact, can launch a book deal on the steps of the courthouse and have freedom of expression, so to speak, within certain legal confines. In Canada, it's completely different. Jurors are not identified, are instructed to not speak about the trial. And of course, in Canada, deliberation is secret under the criminal code. So jurors are not ever allowed to communicate to anyone in any shape or form about the decision that was reached in the courtroom. And thus, so jurors tend to just return to their lives, and there's very little post-trial data on them in Canada, especially from a mental health standpoint because of that condition.
So the criminal code does prevent a juror from discussing the specifics of a case and jury deliberations, for instance. Do these secrecy laws make sense to you from your experiences of serving on jury? Do they make sense to you? Do you understand why they're there?
I understand the secrecy rule. It has as many benefits as it does detractions, in the sense that an individual's right to an appeal and an individual's right to a new trial could be prejudiced by open expression of jurors in the media, and certainly now in social media, about the case. And so I know that those can be difficulties in the US. The law in Canada, it's an older piece of legislation, and it was constructed at a time when our courts and our society was very different. And so sadly, for many jurors who required some form of help, it was very difficult for them to get it. And I was one of those, because of the perceived legal ramifications of jurors speaking openly, even to a therapist. So many therapists were reticent to take jurors on once they identified that they had been in a jury, because of lack of understanding from counselors and the like about the jury's ability to talk. And so I found it very difficult when I was finally, you make that decision, which is a difficult one for a lot of people, as you know. The stigma around mental health and the stigma around seeking help for mental health reasons is enormous. So the fact that I'd finally sort of said, I think I need to do something about this. I'm doing the right thing. I'm stepping forward and I'm trying to find some help. It took over a year to find somebody who would actually be willing to talk to me, because unfortunately I learned the hard way in Ontario at the time that the courts did have juror support in place, but it had to have been issued by the trial judge in the courthouse at the time. And so unfortunately, because that didn't happen, I was shut out from court appointed support, so to speak. And that's another problem with why we have to put fixed access or available access to post-trial supports in place, because of the juror's role and because of the lack of communication between the judge and the jury. Judges don't often think that this evidence could be traumatic, could be a negative effect on the jury. And so counseling is very rarely issued, which is why we need to put these programs in place so that the juror post-trial if they need the help, they can get it readily and freely available.
Okay, so the post-trial support then, Mark, that would be kind of the judge's discretion, or can the jury request that support?
Prior to the sort of events of 2018, a juror, for example, in a case in Ontario, if the juror raised their hand and asked for it, it's hard to say whether it would be offered or how it would be offered. In British Columbia, for example, jurors at one point could, as a quorum of 6 or more, collectively ask for support from the province to receive counseling sessions. And so that was kind of this absurd law that was in, or provision that was in place. And, how is the jury going to come together and collectively decide that they need therapy, and then it may or may not be offered? And so understanding that, I stood up and said that it isn't right to have people who've, again, gone through the system to not be supported post-trial in the same way that we support first responders, we support the military, we support frontline public safety officers in their duty, but we don't do it for the jury, who are in many ways the most vulnerable to trauma.
So ultimately, Mark, do you think we need to revisit the jury secrecy laws that exist in Canada?
Well, there's a bill in place. So in 2017, the House of Commons Justice Committee undertook a nearly year-long study on mental health and jury duty related issues from my petition, and produced a landmark report, which is actually today celebrating its 3rd anniversary of publication. And one of the recommendations in that report was a loosening of the secrecy rule to allow jurors to speak openly with a mental health practitioner. But shockingly, that legislation has gone through the House of Commons 3 times in 3 different bills, the same legislation, but 3 different bills, and has not been successful. And it hasn't been successful because it was voted down. It's unfortunately been a victim of circumstance because it was a private member's bill. And so it sits, the 3rd attempt now sits in the Canadian Senate at 2nd reading, and we're hopeful it will pass, but the clock is certainly running down on that piece of legislation once again.
Just so our listeners are aware, if it isn't passed before the session is ended, you would have to restart the process.
You would have to restart the process right from the start. Yeah, as a new bill, find a champion for it, and which is why we've been asking the government to, certainly in the Senate, to, the Senate's role is to prioritize government legislation at this point, but we've asked the government to move this bill forward because of the importance that it represents to our justice system. But it likely won't. It will still have to wait for government legislation to pass.
And we'll chat again here about reform and what type of things you'd like to see incorporated in Canada. But I do want to focus on the jury for a few moments. You've said a couple times that it's the most important civic duty in Canada, and you're on the record acknowledging, obviously, the hard work and important function of the jury in Canada. Why do you think the jury is such an integral institution in Canada's justice system?
Well, the right to a fair trial is the cornerstone of our democracy and our justice system. And the right to be heard by a jury of one's peers is part of that. And so that is, I think, is one of the greatest achievements of our democracy, to have maintained that principle, so that every citizen has the right to be heard by a jury of their peers. But every citizen should also have the right and have the ability to serve on a jury. So juries shouldn't be maintained only by those who can afford to do it, or those who have the privilege to step away from their jobs, or retired persons. No individual should be shut out from the jury system because they can't afford to do it, or they're worried that there will be employer or workplace reprisals for responding to a summons. So it's a jurors perform an enormous service to the public, and it's our duty to support them, and it's our duty to also ensure that the system is optimal and the process is optimal for them.
Can you tell us a bit about how juries will enable maybe more vulnerable populations to have a voice in our justice system?
I spoke earlier about the process by which an individual could potentially be excused from jury service. So obviously, if you're connected to anyone in the trial, if you've been a victim of crime in the past, if you have any sort of underlying conditions health-wise that would make you unable to serve. But the number of people who have stood up, which is their right at the impaneling stage, have stood up and said, Your Honor, I can't afford to do it. I can't afford to step away from my family, and I can't afford to step away from my job. And they're excused. It was shocking to see that. And it makes sense because jury pay in most of the provinces and territories, and indeed the states, for your American listeners, jury pay has not kept pace with the modern world. Jury pay in most jurisdictions is well below minimum wage per hour in court. And so for so many individuals, it's an economic barrier. I can't afford to do it. I can't afford to step away. And because employers, again, are not obligated to maintain salaries and benefits in most jurisdictions, there's no incentive for an individual to serve. And so rightly so, they step aside. But unfortunately, what that means is that juries have tended to be maintained by people working for corporations that have a collective agreement in place or workplace policies in place that maintain one's salary and benefits. And that's great. We don't want to disrupt that. That's what we want. But it means that people working part-time, people working in the gig economy, people working in retail who are working minimum wage jobs, who are self-employed, don't have that same luxury. And unfortunately, that over-indexes to racialized Canadians. It over-indexes to the Indigenous community in Canada and a lack of diversity on juries. And if we simply raise jury duty pay to minimum wage, or as the House of Commons Justice Committee in Canada recommended, $120 per day, which isn't a lot of money, it's still $15 an hour, that would suddenly change the makeup of the jury. So if we're talking about combating systemic racism in our justice system and the lack of diversity in court, suddenly we do something very powerful to improve literally that composition overnight.
Okay, and I understand we really don't do a great job at tracking which populations or the demographics of people serving on juries in Canada.
It's really difficult to do, again, because there isn't a lot of tracking data in place at the court level, because again, we're not profiling juries. So that data doesn't seem to be there. As somebody who's worked in insights and market research throughout my career, that's valuable data. But again, we don't collect it, or if it is collected, certainly not available to the public. Just the means by which juries are, even the data warehouse, so to speak, on the back end that's actually selecting individuals is different from province to province. So in Ontario, for example, it was shocking to understand that just a few years ago, 3 years ago, the data pool was made up from the municipal housing registry in Canada. So it wasn't from OHIP, which is the health insurance data card in the province. It wasn't from an Elections Canada roll. It wasn't census data. It was literally the municipal records, which immediately indexes to people who are property owners. And so suddenly you're shutting out an enormous section of the population who are renters, who might be long-term leaseholders, but suddenly that was an enormous oversight and course corrected just recently, so that the jury rolls in Ontario are now being drawn from OHIP data. But in other jurisdictions across the country, that's not necessarily the case. It's still being drawn from divergent sources. And we still know that our Indigenous community, some of whom do not receive their health care from OHIP, they receive it from their band and they receive it federally, aren't part of the data pool. And so, like any, this information age that we live in, big data would not be an alien term here. We have to use multiple data sources to feed into the system that draws you out for a jury summons. If it's linking motor vehicle data, if it's linking elections or census data, that would be the best form to ensure the widest distribution possible. And given that census data, you're legally bound to fulfill a census in Canada, would seem to be the best source.
that would help bring about more representation on our juries and making sure that the more vulnerable populations are being included in that service.
At least the likelihood that you will receive a summons.
Right.
And then, of course, stage two, you have to be able to afford to serve jury duty and have the ability to do that without it impacting you financially, which means we have to raise jury pay across the country. In Ontario, for example, you aren't even paid for the first 10 days of the trial, and then it's only $40 a day, which if you've ever parked your car in downtown Toronto, because parking isn't included, you have to pay for your own parking. You're talking about $30 a day to park your car potentially at the courthouse, and then the cost of a meal, which isn't provided. Well, that's your jury pay. And so you're out of pocket, and that's not appropriate. And again, there's a disparity across the country in terms of the rate of jury pay, which is why we've asked that all provinces step up to the $120 a day. And some provinces have exceeded that, but some still are well below.
Just curious about British Columbia. I think I saw in the 2017 report you mentioned earlier, their jury allowance was quite low. Do you know if they've recently amended that?
They have not. It's still low. So it's $20 per day, and then it rises to $60. And then I think it taps out at $120, but well into the 100th day of the trial. And so for those early stages of the trial, again, if you're living in Vancouver and having to travel into the city, or if you're living in the outskirts, it's incredibly expensive. And again, it's a barrier to participation. I can give you an example of a high profile trial recently before the pandemic, where an individual on the jury, a senior citizen on a fixed income who was counting every single penny, said to the court that they couldn't afford to travel, and that they were experiencing extreme economic hardship coming into the courthouse, asked for financial help, and it was denied, and that individual stopped coming and put the trial in jeopardy. And then luckily they were able to make an arrangement for that individual to save the case and from it going to a mistrial. But that shows you that how important this is. And then again, it's our civic duty, but it's not your duty to suffer, and it's not your duty to suffer financially. Jury duty pay has to be seen as income support now. It's not an honorarium. It's not a pat on the back support from the 1950s. It has to be seen as income replacement. If your employer is not obligated to pay your salary, thus jury pay has to be an income replacement.
In the ideal world, Mark, if I gave you the magic wand, would you like to see an employer be responsible to continue paying an employee?
In many not many, I would say in very few jurisdictions, but in Newfoundland and Labrador, that province, that is the case. So they don't supply jury pay. You're mandated to maintain your salary. The employer is mandated to maintain salaries and wages. In several Australian states, that is the case. And then they have raised jury pay in those regions to quite a substantial rate per day to allow self-employed individuals to sit on a jury. And in some US states do have that in place, but it's only a handful of them.
So making sure that jurors can survive and they're not losing money to fulfill this duty is obviously, seems very obvious to me anyway, to be quite important.
It is. And it would, again, it's an investment in our justice system that will pay dividends, because it's improving the public's perception of jury duty, and the years of neglect and eroded attention to jury duty has resulted in a terrible public perception of jury duty. When we launched a survey at the beginning of the pandemic to understand the public's willingness to serve on a jury when the emergency lifted, jury duty sat lower than donating blood or willingness to volunteer for a community organization. The only thing that was lower was volunteering at a hospital for obvious reasons. So jury duty sits well below. And again, that the insight is because of neglect and because of public's lack of understanding and again, too many bad experiences that have tainted the public's perception of this important civic duty.
Can you talk to us about how the pandemic and COVID may increase the stresses of serving on a jury and may cause some issues for our justice system?
Well, the pandemic has obviously impacted every industry across the board, and our courts are no exception. And the enormous backlog of cases, and obviously some jurisdictions like Alberta has seen a limited number of jury trials, but most of the courthouses have been shut across the country. And with that backlog of existing cases, we all know that our courthouses have been delayed and backed up. Now that, coupled with crimes that were committed during the pandemic, are going to require an enormous impaneling of juries when courts reopen. The economic conditions of the pandemic have obviously created a divide between haves and have-nots in our society. So there are some who've done reasonably well as a result of the pandemic, and there are others who are increasingly economically challenged as a result of the pandemic. The mental health data across the board that has come out during the pandemic has been one that has seen a dramatic increase in depression, anxiety, and stress as a result of the stay-at-home orders and everything associated with the crisis that we're in. Taking those pressures suddenly on top of a summons, there's going to be, I'm deeply concerned about Canadians' ability to serve and respond to a summons. Again, so many individuals will have an opportunity to raise their hand and say, Your Honor, I simply can't do this. I'm not able to do it for a myriad of reasons, for mental health reasons as a result of the pandemic, for economic reasons and economic challenges. Workplaces are going to be in many ways the most resistant to jury duty summons amongst their employees, possibly since the war, because workplaces are hanging on for dear life in many cases. Some businesses have been shut and maybe have been surviving on obviously the government subsidies, which will then be gone. So businesses will be retooling and wanting to reinvest in operations. And so a summons is the last thing that a business owner or a director is going to want to see and respond to favorably. So that's why we have to make these investments in jury duty, because of the fragility of the system coming out of this pandemic. So the justice system is no different than any other institution coming out of this pandemic on the other side.
We chatted about some of the stresses of serving on a jury and how there's not really a ton of support for income and following your service on a jury. I've talked to some academics who have looked at jury comprehension, and I'm just curious to get your thoughts on whether you believe jurors are given enough support in terms of understanding what's going on in the trial. And the reason I ask this is because obviously a trial, like first degree murder trial, like that you were involved in, there's potentially very complicated evidentiary issues that judges and lawyers struggle to really even understand. So I'm just curious, with your experience, do you think jurors are given enough support in terms of appreciating the evidence that's presented and understanding the evidence that is presented?
Well, even before we get into that, there's an information gap about jury duty, my role as a citizen, how this system works, my responsibilities, my rights, all of those questions that individuals have prior to going into court on their first day for impaneling. So many individuals have said, I looked for information on, is my job going to be maintained? I couldn't find it. Or I was diving through website pages that led nowhere. And certainly nobody was returning my call at the courthouse. I didn't understand what was going on. So there's an information gap at the front end where we just haven't provided enough of the right information to citizens so that they understand the system, their role, to bring them into court confidently. Certainly once in court and having assumed the role, there really depends on the justice. It depends on the agreement with counsel of what information has been provided to that jury. So certainly some justices have done very well in terms of explaining, the difference between hearsay, fact, evidence, and have produced very clear statements of fact and the like. It's a delicate balance between opinionating a jury member and providing them with information to assist them in their role to reach a verdict. And that's a delicate balance act. And again, some justices that I've talked to, again, have been very critical of the charge, which is the document that the justice produces, which is presented to the jury, which is essentially a summary document of the evidence, the charges, and the case in totality. I remember the charge that I received in my case was over 300 pages long. It needed a wheelbarrow to get it to the jury room. And some justices have produced very thin charges, which didn't have enough information possibly. And so again, it's a delicate balance act. And obviously that's something that I think the legal community have to undertake as well. And that's probably a more in-depth conversation. But we have to provide the jury with the right information at the front end of the trial. And then at the other end, a lot of individuals have said during the dismissal, once the verdict had been given and they were excused from court, many people were shocked that they literally picked up their bags and left, that there wasn't a dismissal and that there wasn't a very organized operational debrief of what's next. What can you say? What can't you say? How do you interact with the media in a high profile case who might be waiting for you outside the courtroom? What are my responsibilities as a former jury member in terms of maintaining silence and not communicating about this trial? So a lot of individuals have said that it was hard to just walk out of the courtroom not understanding what was next and expecting more. So that's one of the recommendations from the Justice Committee as well from 2018 in their report, that there be a proper organized debrief and dismissal. It was very nice that the justice in my trial came in and had a cup of tea with us after a 4-month trial, but that's rare. Very, very rare that justices come in and physically thank the jury. Most jury are excused in court and literally pick up their bags and leave.
So in general, that's still pretty much the experience for jurors. When they're done, there's not really a debrief.
There's not a debrief. The bailiffs, sheriffs, or constables that manage you in the courtroom on a day-to-day basis will greet you in the jury room. You collect your suitcase because you might have been sequestered for a week in a hotel, and you pick up and go. And a lot of individuals, certainly after a traumatic, difficult trial, we're hoping for that. We're hoping for the ability to sort of stepwise come down, so to speak, from the event, to be able to leave the courthouse and step back into the public, especially after weeks and weeks. They're rare, but a week of deliberation on a very difficult charge is intense. And a lot of jurors have said it was the deliberation that was the most difficult part of the trial. And I felt that I needed more.
And just sticking with deliberation for a moment, Mark, do you believe deliberation? I know you can't talk about any specifics related to it, obviously, because of the laws in Canada, but is deliberation, do you think that's an effective way for people on a jury to really hash out all the evidence and come to a reasonable verdict?
Well, I don't know of any other means, to be honest. It's sort of, that's the tool with which we manage in court in Canada. I think in some European countries, there are professional jurors, so to speak, who would be subject matter experts in certain areas, almost like micro judges who would oversee a case and thus are learned and trained in the law. I think, again, jury duty and to be tried by a panel of one's peers is one of the most important features of our democracy, and it's one that we need to protect, especially even in civil cases where there is a decline in the number of civil trials that go to a jury. Certainly in the United States and in Canada too, civil trials are under threat, and because of competing forces who prefer to see these trials tried by a judge. And so again, it's important that we protect that facet of our society, but it comes with making an investment in it to make it work.
So this is a bit off topic, Mark. Before we get into discussing the Canadian Juries Commission and the work that you're doing, I wanted to discuss retrials, because in the first season of our podcast, we're looking at the case of Peter Beckett here in British Columbia, who underwent 2 jury trials. And you and I chatted off record here about, some of the stresses that would be involved as a juror watching a retrial. And I know some jurors have talked to you about that. Can you give us a sense of the type of emotion and feelings a juror would have in watching trial they were a part of have to go through a second trial?
Many have expressed deep anguish about seeing that take place, that practice, and obviously understanding that that's the system of justice that we live in. But certainly in a case where the jury struggled for weeks to reach a verdict in the case that they sat in. Again, jurors are not responsible for the evidence that is presented to them. They're not responsible for the quality of the evidence. They're not responsible for what it is. They're responsible for making a decision based on the law and the instructions of whether that evidence meets the thresholds for a verdict. And certainly if the case, again, a hung juries happen. And again, that's the burden of the job, so to speak, of being a juror, is that one might not agree and might not be convinced. That's important. That's delivering justice. That is what the system is designed to do. And I've talked to individuals about that. And again, that's some of the work that we want to do post-trial, to unburden the burden of the guilt and anxiety and depression that those jurors have felt of not being able to carry justice, or even a lesser charge, so to speak, or a lesser verdict, as it were, in the eyes of the public or in the eyes of victims, perhaps, not being able to convict on anything more than manslaughter. But then to see it retried again and to see it either fail or succeed is very, very difficult. And certainly it brings it all back. Parole hearings have the same effect on an individual as well when they're brought up for parole. And certainly there's been very rare cases, but I've talked to an individual who has seen an individual commit a crime again in society years later, sort of reappear in the justice system. And again, that causing trauma. So, which is why we have to provide peer support, and we have to provide post-trial support for individuals who, in order for them to get through that moment and to continue with their lives and to get back to their families and to get back to their work, and not to have that linger and manifest in ill mental health and substance abuse, collapse of marriages, relationships. It's really important.
So I want to turn now to discussing the Canadian Juries Commission and the great work that you guys are doing. I figure we could start with maybe how you came to manage your PTSD and the decision in starting the Juries Commission.
Well, post-trial, again, as I indicated earlier, it took almost a year for me to finally find a therapist who was willing to take me on and formally diagnosed me with PTSD and anxiety, and work through my experience as a juror. At the time that I was going through therapy, I was also writing to the Attorney General in Ontario, and also to basically every jurisdiction across the country when I started to dig into it and research it, to realize that I wasn't alone in this experience in Ontario. Almost every jurisdiction at the time had no post-trial supports for jurors. And I kept thinking, I can't possibly be the only one that this has happened to. And so I started again to do some research and started to write to the federal justice minister, writing to deputy ministers, and wrote a lot of letters that really weren't going anywhere. And it really started to talk to people in the legal profession, started to talk to friends who were lawyers. And so many people had just never thought about this before, because it's so abstract. If you haven't been a juror and you haven't gone through it, you would never think about this as a member of the public. I would never have thought about this in my entire life. But putting those questions to individuals, the light bulbs started to go on. And I had a battle on my own at the time too, which was sort of accepting my role. I kept thinking, maybe this is my problem. Maybe this is just part of the job and I just have to suck it up. And that, this is the system. It is your duty. You have to fulfill it. And what happens to you on the other side is your problem. And I came to terms that that's a stigma of mental illness as well, is that it speaks to you in those terms. And I wasn't willing to accept it. I wasn't willing to accept that this was a character flaw, that I developed PTSD. And I wasn't willing to accept that this was, something that I deserved. And so finally, in speaking with some friends in the legal community and researching the Paul Bernardo trial, which was arguably Canada's most notorious trial, one of Canada's most notorious trials to date, I learned that Justice Lesage, who tried the case and then became the Chief Justice of Ontario, provided the jury with counseling in that case post-trial. And that was an exception as opposed to it being policy at the time. So really he had to go out and acquire counseling for the jury, and all 12 took it. And so I thought, who better to write to and address my concerns than him? And so I wrote probably the most impassioned letter I've ever written in my life, and mailed it to him through the Judicial Institute, and he responded to it very quickly. And I was on the phone with him within a few days. And after a very lengthy conversation, he understood and gave me, in many ways, the conviction and the willpower to move forward in this. And he understood the problem, and which led really to Ontario introducing the juror support program when it did in 2017. So that spurred me on to, I could have stopped there, but I wasn't willing to accept that, this was still happening in other regions of the country. And I wasn't willing to accept that, so Ontario has a juror support program. I was very pleased to see it in place, but we can't have people from other sides of the provincial fence looking into Ontario and wondering why they have counseling and I don't. And I've just gone through this traumatic trial. And so, again, that sort of spurred the movement of the 12 angry letters. So jurors from landmark cases, after I started to go public and do a lot of media interviews, reached out to me and shared their stories. So jurors from the Paul Bernardo trial, jurors from the Jennifer Pan trial, the Tim Bosma case, the Tori Stafford case, and cases that you probably haven't heard from that were just deeply, deeply affecting. And we took those letters to the Justice Minister in Ottawa, which led to the Justice Committee taking on that study. The Juries Commission was born out of the report that the Justice Committee issued, and really, to be fair, this sort of the lack of response from the report once it was issued. There was a lot of attention around it and a lot of nodding of heads, but really there wasn't a lot of action. And so when you look down the recommendations of the report, it's really the DNA of the Canadian Juries Commission, to provide post-trial supports and supports for individuals who've served on juries, to promote better pay and better conditions on jury duty, to promote more and provide more information to jurors about their roles and responsibilities at the outset of the trial, and to ensure that workplaces do their part to support their employees serving on juries.
Okay, well, kudos to you for doing all this work. It's really important, and obviously there's been improvements in Ontario and a lot of discussion around this. I know you do a lot of interviews and are a fierce advocate for your cause, which has been really inspiring to read and to listen to some of your other interviews, Mark. So again, kudos to you. I'm just curious what your experience has been in dealing with politicians and governments. You said that the report from the Justice Committee, there were a lot of great recommendations in there, and we'll link to that in our show notes. But what has your experience been like in dealing with powers to be?
It's almost its own episode.
I'm sure it is. I know that's a loaded question, but I'm just curious because, like you said, there hasn't been a lot of great recommendations in that report, but from what I understand, there hasn't been a ton of action to date.
It's the report is the blueprint for action, both at the federal level and the provincial level. And jury duty, unfortunately, falls into that enormous tension that exists between a federal government and the provinces. Jury duty is a federal mandate, but administered by the provinces. And so, like healthcare, there's still an enormous friction between those two bodies. And so that friction almost always results in no activity, because one body might say, well, that's not our jurisdiction. And the other body is saying, well, in order to exercise that, we need federal funding. And so a number of provinces have said, we'd love to raise jury pay, but we can't afford it. We would need a federal transfer in order to do it. And then again, over to the federal entity, which says, no, that's not in our position to fund the provinces to raise jury pay. So you're stuck in this no man's land of inactivity. And so in many cases, it's finding a champion at the provincial level who understands the issue and is committed to action. And sometimes it's timing and sometimes it's opportunity. that's often the problem. And so, nobody has, at least in recent years, nobody has refuted any of these recommendations. It's finding the ability to achieve them. And which is why the pandemic, sadly, the pandemic is again the right time for us to invest in the justice system, because again, it's the most vulnerable. And as we're retooling our society to be, re-engineering our workplaces, making investments in our economy to come out of this in a healthy fashion, we have to do the same for the justice system. It can't be left idle, because all of the conditions that we have raised predate the pandemic and have now been compounded by it. So certainly government-led legislation and bills are more successful and more likely to succeed than private members' bills. And so we've been really fortunate to have private members' bills introduced by multiple parties of different stripes, but they're still private members' bills, and they have to sit idle until government bills are passed. And then often in the case, they don't survive. And again, you have to go back to the drawing board. And judges in Canada are sort of uniquely positioned in the sense that, again, there's a lack of ability for them to influence the government directly because of their position of being a judge and being impartial to influence government legislation. I've been fortunate to have presented at the Supreme Court of British Columbia by invitation of the National Judicial Institute to just talk about juror mental health and talk about that, and justices understand it. And so again, another pillar of our work is to educate the court on the potential trauma of jurors, so that more work can be done for them post-trial. And so that jurisdictions that do have that post-trial counseling in place, but it has to be issued by the bench, they can think about it and make the right decision. Because again, a lot of the court, other actors in the criminal justice system, there is a level of desensitization that happens to individuals day in and day out in the court. And so people don't think that this evidence might actually have a terrible impact on people who've never had to witness this before, because you see it day in and day out. It's not to say that it's not traumatic for them, but they have coping mechanisms that they've developed in their vocation that the jury just simply don't have.
That makes sense. I mean, if you're seeing it on a regular basis, and you can come up with these coping mechanisms, and there's also not maybe the same restrictions in their ability to talk to certain professionals about it.
You also have peer support. Many, first responders, police associations, the legal profession, even the justices themselves have access to supports that just simply aren't there for the jury, which is why we're making an investment and have asked for an investment in peer support, which has become, rightly so, a big part of the mental health movement. People with lived experiences, passed through, so to speak, and have come through it can be an enormous form of support for the next generation, so to speak, of individuals going through that. Because again, I've talked to so many jurors who've said, yes, the evidence was graphic, truly. The deliberation was difficult, but it was really difficult for me to adjust to my life back at work. And it was difficult for me to adjust to my life at home. I just didn't feel the same. And I don't know how to express that. And I was just lost for 6 months. I've heard this from so many individuals who've just said, and I can't talk about it to my work colleagues. They won't understand. And I can't really talk to my friends and family about it because they don't get it either. And, there's so many people who you might say like, oh, wow, wasn't it great being on a jury? That must have been so interesting and so exciting. And for many it was, but it's that reintegration that's missing. So they just want to talk to somebody who understands. And that's a juror. That's a juror peer supporter is so necessary and so important.
Right. So Mark, the report that came out of the Justice Committee, the recommendations in that report, you mentioned that's kind of the blueprint for what you would hope jury reform would start to look like in Canada. The legislation that you're trying to get passed, is that essentially trying to incorporate all of those recommendations?
Well, there hasn't been a bill put forward to take on that entire report because of the division of ownership on each of those items between the federal government and the provinces and territories who administer jury duties. So, the federal role really lies in the recommendation to loosen the secrecy rule, which is Bill S-212, which is sitting in the Senate now, and the call to action in the report for a one-time investment by the federal government to the provinces and territories to essentially fulfill the recommendations of the report, which is not, again, would not have an enormous burden on the taxpayer to manage this. And then the provinces would be responsible, again, for post-trial support. There's no reason that post-trial support for the jury could not be done in conjunction with many of the great mental health institutions and hospitals and the like. The jury doesn't even need to know that they're potentially being triaged on the phone post-trial by a clinician at a hospital. We can skin the programs, so to speak, in the brand of the jury support program, but it's administered by a hospital. We have to make sure that the jury have access to the same evidence-based clinical assessment and evaluative tools that first responders do, that's trauma-informed, so that the right people with the right experience are managing the jury and are in place to see them through. And that's why we've argued it's great that provinces have put programs in place, but limiting the number of sessions to 4 or 5 or 8 isn't appropriate, because we don't, no clinician really would say, you're in here for 4 sessions and that's it. A juror might not even be able to come to terms and break down the source of the problem in 4 sessions, let alone begin talking about coping mechanisms. So Australia in Victoria State has a great juror support program through the jury commissioner. It says it's really a decision between the clinician and the juror, and we just pay the bill. And so if it's 20 sessions, it's 20 sessions. If it's 5, it's 5. But the individual has to feel confident that they've got the coping mechanisms in place and are able to move on.
So, Mark, I appreciate that because of the way that Canada is set up and federalism, and there's a federal government and then the different provincial governments. Those are some of the hurdles and challenges in terms of getting real jury reform set up in Canada. But if I gave you a magic wand and you could implement what you think really needs to be just the foundational or the basics for jury reform in Canada, could you give us an idea of what you think needs to be set up? If you could do it, set it up right away. We talked about the necessary income replacement and having the employer support, peer support systems in place. But are there any other things that jump out at you right now that you think need to be established straight away?
Well, education is key to all of this. And certainly we have to put more emphasis on jury duty and civics classes in modules at a much younger age. There really is nothing. I don't remember having anything about jury duty taught to me when I was in school, and it seems to be the case now. And so the provinces, if I was to wave my magic wand, we would have a section on jury duty immediately following our discussions on the criminal justice system, on our parliament, and all of those discussions around civic activities. And I think law schools, absolutely, it's shocking that there isn't a module on jury duty and juries, both on this civil side and on the criminal side. And obviously more education to justices on jury-related issues with the bodies that train justices in their role when they are called to the bench and are appointed. That's necessary. That's again what we've asked on sort of standardization. That's why we've asked the federal justice minister in Canada, and the same would apply to the US and the United Kingdom and other jurisdictions that have jury systems in place. When the federal attorney generals meet with their provincial or state counterparts on an annual basis, which they do every year and routinely meet, that they champion these issues and that they look at jury pay. And certainly in the States, the disparity of jury pay on a state level is enormous, from no jury pay and in some states, 0, to still only $50 a day at the top end in most states. It's shocking. And in Canada, again, So encouraging the provinces to standardize and meet that standard, it's so important. But you have to have that champion there to do it. And then again, as we're talking more about trauma and we're talking more about supports, again, that universal acceptance of post-trial support and investing more in jurors has to be done, and again has to have that federal champion doing it.
And Mark, I follow you on social media and I see all the great work that you're doing, but you're also a champion for just mental health awareness in general. Can you discuss the Canadian Juries Commission relationship with organizations like for example, Canadian Mental Health Association?
Well, we're really fortunate to have a great partnership with the CMHA and the Center for Addiction and Mental Health as well, who understand obviously these issues. Funding is the key to it. Sustainable funding. It's one thing to demand the programs, so there has to be funding to support and maintain them and establish them as well, which is why we were fortunate to have been invited to the Standing Committee on Finance in February 2020 to deliver a pre-budget submission to the House of Commons for a mandate for the Canadian Juries Commission, a 10-year mandate, and had the unanimous approval of the Finance Committee to support that pre-budget consultation. We were part of their report, but unfortunately the pandemic happened and the government's attention shifted, rightly so, to deal with the emergency measures of the crisis. But again, we've stated that an investment in jury duty is necessary for all of the reasons that we've discussed throughout this interview. That it's the most vulnerable right now post-pandemic, and Canadians are going to be again more likely to want to be excused from jury duty for very real reasons, and we can't be critical of those reasons because they're facing us all: job insecurity, ill mental health, family obligations, childcare obligations that may still be unstable, elder care obligations, post-pandemic, post-COVID healthcare obligations that the virus has materialized that might have affected elderly members of your family who contracted the virus. So this is why we have to invest in this system to ensure that it's sustainable and stable. So jurors have, on top of mental health concerns, have discussed concerns for privacy and their safety in and out of the courthouse. And really this concern has been around for decades. But now, certainly with the digital world that we live in and the prevalence of data and creep, so to speak, it's even more important to secure the anonymity of the jury in Canada and obviously in other regions as well. But jurors, from their physical security, have talked about the fact that certainly in gang-related cases and organized crime, where they're sitting in the courtroom and supporters, so to speak, of the charged might be in the courthouse to support their members. Jurors have discussed being followed to their car or to public transit out of the courthouse and being intimidated by gang members or supposed people just following them for no reason. And that's unacceptable, one. And that's a threat to the sanctity of our justice system. So any individual who raises those concerns, that should be addressed immediately. And it was shocking to hear how long it took for the court to really start to, in those cases where jurors brought those concerns forward, the fact that the court didn't respond to them was shocking. And this happens in big cities, but it happens also in small towns and small communities. And you can imagine that, when a trial takes place in a small town, in a small courthouse, where everybody in the community knows one another, that's an enormous problem too. And in some cases it's unavoidable, but certainly during the trial itself, there should be a measure for the jury to be able to park their car securely in the same secure parking lot that the judge uses and that other actors in the courthouse use to be removed from the public. And so that they're able to travel to and from the courthouse freely without that worry. I heard from a juror in a biker related case where they came to the courthouse and parked their car and were surrounded by bikers on either side of the car who weren't, intimidating her directly, but certainly weren't allowing her to get out of the car freely and to be able to go in and out of the courthouse and to arrive safely. That's just unacceptable. And that those stories of intimidation, again, it's not fiction, it's really happening. That's something that the courthouse and the system can amend and invest in very simply and very easily. The other side of the coin is the data security and data privacy concerns that jury members have. And certainly facial recognition software right now is a deep concern for our organization, in the sense that anybody with a smartphone, if it hasn't been checked by court staff, could simply sit in the public box, in the public gallery rather, and very easily train that phone to members of the jury and capture their identity through facial recognition software, through just open tools like Facebook. And we know that is happening because jurors have expressed to us that they've suddenly seen their social media be creeped by people who they would never have associated with in their life, and friend requests and from people that they don't know, and suddenly these are starting to come in, and that's a concern, and that needs to be addressed. And the Privacy Commissioner of Canada has recently raised the alarm about facial recognition software in the broader societal context. I echo those concerns and address them directly to improve security for the jury, which was one of the recommendations from the Justice Committee's report.
Mark, do you think this is maybe too dystopian or something you see on a Black Mirror episode, but do you think it's necessary to maybe start to at least discuss whether the jury should even be in the courtroom in a high profile case where you have, whether it's a bikers or gang type trial where there's a high profile defendant, for example, or accused? Do you think maybe we should discuss whether it's appropriate to have jurors either secluded and watching from a different room, or do you think that's just unlikely to happen?
It's a great existential question. It's not dystopian because it's happening now. There are cases of it happening right now in this country and in other jurisdictions around the world. The El Chapo case is a great example of the sort of extreme of that concern. And I think the court met and had to think about those concerns in New York State, maybe for the first time in a generation, about the jurors' safety, their right to privacy, their right to security. And that, again, that's the most extreme, where the defendant had to promise and write a legal document, was prepared to ensure there would be no retribution on the jurors. I mean, that's utterly unthinkable, but that was the case. But information security and information privacy is going to be an ongoing issue as these tools become more available, more sophisticated, and data streams just are more fluid. And so the jury's right to privacy is going to be consistently challenged, which is why we have to sort of meet these issues head on. Certainly, the judge's prerogative to close the courtroom, to not allow any members of the public in a case like that, has happened and is a mechanism that the justice system has in place now. But I think the data concerns on the one end, and just the physical security concerns that jurors have talked about for years, can easily be addressed by, again, affording them private parking and just allowing the jury to park their car under the courthouse.
Yeah.
And we're not talking about suddenly an epidemic of parking concerns. It's 12 people in one case who have to park their car down below. And once you express that to justices, and I did so in a presentation not too long ago, they all acknowledged it. They said, and many just said, I'm going to do that. I didn't know they could, but many had just forgotten that there was a mechanism to do that. It's something we need to do.
So Mark, right now, how is the Canadian Juries Commission funded?
We're not.
So
we receive no public dollars. So really, it's being run out of my pocket, and it's being run out of the generosity of my incredible board of directors and advisors who've committed to this organization. Board of directors is made of clinicians, psychiatrists, psychologists, some great litigators, former jurors. My partner, Tina Danzer, was juror number 1 on the Paul Bernardo trial and has made a commitment to this organization. We have members of the Indigenous community on our board, but we modeled ourselves off of the Mental Health Commission of Canada, which received a commission as an act of parliament and was given a mandate and now an extended mandate. We modeled ourselves off of them to be that bridge between the federal government and the provinces and territories, again, to be a solutions catalyst to the provinces to build programs that they can use. Just like the Mental Health Commission has built programs and toolkits and solutions and research and advocates for mental health in both directions, we would be doing the same for jury duty. But sadly, the pandemic, like many things, has stalled our ability to seek and receive funding. So that's where we are.
Where can people go to support Canadian Juries Commission? Do you guys have the option of accepting donations?
We haven't set that up yet because we wanted to be impartial. So we have not set up that mechanism. The best place to find us is on, we have a Twitter account. So it's at Canada Jury, all one word. We have not built a website yet, which might be shocking to some people, but because of so many jurors who've gone to websites to look for help and look for support, but not been able to find it, we didn't want to establish a site that, again, was just an information source with no teeth to it. So until we're fully funded and our programs are operational, we sort of kept our website offline. But the best means to get in touch with us is through Twitter or through my Twitter handle, which is at CDN Jury Help.
Okay, and we'll put those in our show notes, the how people, the two Twitter handles that you mentioned. And Mark, in closing here, I just want to ask one final question with respect to, assuming we can get past this pandemic here. I think we're starting to see maybe a glimmer of light at the end of the tunnel here with vaccinations rolling out. Do you think that with more recognition around jury service and the problems that are associated with jury service, are you optimistic in the direction that we're moving in Canada?
It's a great question. It's hard to have a crystal ball on that one. Like many institutions and many obligations, it's under enormous pressure. And so it could go either way. I worry about Canadians' ability and the desire to respond to a jury summons post-pandemic. It's going to be the most fractious time for many people, again, for all of the reasons we've discussed about, retooling their employment, so to speak, their own economic fragility at home, and certainly, again, for individuals working in industries that have been shut out and shut down because of the pandemic, their ability to respond to the summons is going to be even more challenged. One of the big programs that we're bringing forward right now is simply just to acknowledge a Juror Appreciation Week in Canada, which is shocking that we don't have it. In many states in the US, your American listeners would know that California and Texas, New York State and Missouri, for example, have had a tradition of Jury Appreciation Weeks where jurors are given, even just things like certificates, badge, a pin, from one end to enormous outreach, posters, promotion, education, members of the bar going out to schools and institutions, and just a lot of civic engagement during that week to thank the number of citizens who've done and performed their civic duty to promote the importance of jury duty to the public, and as a time to shed a light on jury duty, to provoke change, all of those things. And it's just another one of those things in Canada that's shocking that we don't have it. So I'm working really hard to establish a Juror Appreciation Week nationally in Canada. We're hopeful that a motion is going to be entered in the Senate this week to ask the government to respond and to acknowledge the week, which would be the second week of May in Canada. And it would sit obviously at a time, I've recently spoken about it, on the anniversary of one particular trial, which is the Tory Stafford case. But it reminds us all of, that the jury performed an enormous duty to the public in a really difficult trial, but also, to commend them for that experience, and obviously to acknowledge that the experience had an effect on that jury. It's an opportunity to do all of those things.
Well, Mark, I'll certainly be supporting your work, and I'm eager to follow the developments here. And I wish you all the best in your hard work here. I know your tireless efforts here. I'm very impressed, and I wish you nothing but the best of luck moving forward here. And I can't thank you enough again for coming on to our show today.
Oh, it's my pleasure. Thank you so much for those kind words and the opportunity to speak to you and your listeners.
And no problem. And maybe as we move along here, we can find another time to chat.
Absolutely.